Good morning. Good morning, well wishers and followers. At Eka Infra, we have always strived for achieving technical excellence. And in this endeavor, one of the key aspects that we have been focused on is training. All of us have in our careers been exposed to training through one medium or the other, and training has also evolved over time. One such medium that we propose to introduce is the use of podcast-based interactions between an expert from a specific discipline and a group of like-minded staff who engages in a discussion. We are starting such an interaction today within Eka Infra with a discussion on contract management. And the specialist who will be interacting with our staff will be Mr. Srinivasan. He has vast international experience of over 35 years and hands-on dealing of projects and contract management, and has held key managerial positions in multinational companies. Since retiring in 2013, he provides advice and guidance on the subject. He is associated with Eka Infra since the inception of the company. Srinivasan sir, thank you for your time. Let's deep dive into the subject, which is contract management. Contract management is a vast subject. A single podcast may not be covering the entire gamut of tasks that a contract manager performs on a project or within an organization. We have thus selected a few questions for our discussion in this forum. Let me start by asking the first question. Sir, are contract managers needed on project teams?
The answer to the question, are contract managers needed on project teams, is yes, in a short way. But we need to understand a little bit the background and the environment in which businesses operate today, which make this specialist position essential in all project teams. In the late 80s or early 90s, um, government projects, infrastructure projects started moving towards private sector. And along with private sector came in lenders who really bore 70% of a project cost. And therefore, for lenders, if there is a non-performing party within a contract, he has to take the liabilities for whatever he has not performed. And since so many contracting parties are involved, okay, each party has to protect and preserve its rights, entitlements, and ensure that he doesn't take the liabilities. Therefore, this contract management function commenced in 80s, and today it's a well established and considered an essential position in all project teams. And we should also remember that a contract management is a team effort within the project. A contract manager cannot do his tasks alone. He has to interact, and everyone else in the project team has to interact and then ensure that the contract management is properly done.
Yeah, I completely agree with this point of view. And I'm sure, a lot of us today in today's contracts where we find quite a lot of, intrinsic claims and EOT, extension of time requests flying back and forth. I think contract management has to be focused on being at site most of the time.
Yeah, yeah, yeah. Yeah, you rightly brought up one more on the time. Today, the time schedules are very short because the investors and lenders, by shortening the execution time, are looking to improve their returns. Okay. And therefore, when the project time schedules are very short, it is very essential that each party performs its task on time.
This leads to the next question then. Is the role distinct from a finance function?
Yeah, see, a finance function you need in all project teams. Um, Basically, you call him a finance manager or a financial controller of a project. He has to deal with preparing proper invoices to the client on time with the supporting documents. He has to handle taxation. He has to consolidate the results of the project. He has to monitor the budget versus actual spends, etc. See, we talked earlier about interface. Supposing a payment is delayed, an invoice is submitted by the finance manager and the payment is delayed, then the contract manager comes in to exercise the remedies. Okay. So there is a distinction between, like for example, if there's an engineering manager in a project, if there's a delay in approval or if there is a change in there's some engineering requirement, a contract manager comes in to pursue a change order or to pursue remedies for delay under the contract. Therefore, these are distinct functions. And contract managers' job descriptions to fit into project teams are fairly standard in most project companies. Yeah, there are distinct job descriptions for both these functions.
Now, moving on to the details of contract management, let's look at what are the key clauses to note while bidding and entering into subcontracts.
This question uh, itself could lead to certain dilution and shortcuts amongst the project team members. There is no substitute for everybody in the project team to read the entire contract document. They have to read the entire contract document. See, for example, if a civil engineer says, I will read only my civil part of the specification, I don't read the rest, we will end up in disasters. Okay. This is a this has been proven many times in such projects. Therefore, there is no substitute to reading the full contract document. Every team member should read the full contract documents. Okay, some of them may not understand everything, but they will at least, if they read it, they will know there are things here which they should get clarified or try to understand. Okay. Of course, when we talk in the context of contract management, we generally look at the terms and conditions of the contract. Okay. And and if you look from a legal or contractual point of view, a lawyer will look into warranty, indemnity, liability, delay. We generally call this WILD, W-I-L-D, warranty. What have you warranted? What are your warranties or defect liabilities? How long is it? What have you to do? Okay. What happens if you don't fulfill these? Okay. Then you talk about indemnity. So you indemnify the other party of certain liabilities. Okay. So indemnity clause is something which everybody should understand. Liability. If you don't perform, what comes to you as a liability? What is the amount? What are the caps, etc. And then, of course, there is delay because delay is a fundamental issue in every project. Almost every project, I would say 99% of the projects, okay, they are delayed. And the question is who is responsible, what happens, why is the delay? So delay is a very important clause. So my submission here is just don't ask for key clauses. You should know your entire contract. Okay. And some of these four items which I mentioned, they will bring in a lot of financial liability. So lawyers and contract managers often look at the wording of these clauses and they try to educate the technical team members about these provisions at the start of the project so that they have some understanding of what liabilities will come in case we don't perform.
I think a very pertinent point because even today we struggle to get all our engineers to read the contracts in detail. As you rightly said, most of the engineers on site, they limit themselves to what their domain is. And if a site engineer is looking at the contracts, he just refers the technical specifications or the drawings that he is likely to be associated with as part of his job responsibilities.
It's very essential that all the members of the project team have read the contract and had some discussions about just not these four clauses I mentioned, about the entire contract and how they intend to perform to close this contract out at the end of the warranty period. This understanding is very essential.
The next question that we have is how can a party preserve its contractual rights, having understood the key clauses and what would you need to note for while bidding for or entering into contracts or subcontracts?
Rights under the contract will flow to you only if you perform. If you don't perform your obligations, you will most probably not succeed in trying to emphasize your rights because you have not performed yourself. So in most of the contracts, to preserve your contractual right, your own performance is very, very key. You should ensure that you perform that. Okay. And of course, if you perform, you should perform to your quality, you should perform to the time, you should perform to compliance with this, with the specification, etc. And you should try to carry out all your obligations in time. Okay, not just that I've done engineering, I've done some commissioning, but every other requirement under the contract, there will be several of them. When do you train people? When do you train the owner? When do you give him training manuals? So many of these requirements are there, which are your obligations. You should perform all of them. And then when it comes to preserving the rights, the most important thing is to issue a notice. See, if the other party, the client, is in breach of his obligations, and as a result, you are getting delayed, client requests you to notify. Many project teams hesitate to issue a notice to the client. Supposing the client has to give you fuel on a particular day. 1 week earlier, you see he's not able to give you, so you should remind him, and on the day when it was due, you should give him a notice to say, you're not given me the fuel, I'm waiting. Clients say, you notify me if there is a breach in my performance so that I rectify it. So a notice by itself is not a claim. And many project teams are scared to issue notices because they say client will react. What will you do? How can I give him notice? But they forget that in most contracts, if you don't issue a notice, you lose your right to claim. Some contracts explicitly mention it. Some contracts don't explicitly say that you lose your entitlement. But even in case there is no explicit provision about your losing your rights, if you don't issue a notice, this will be the first stumbling block for you in preserving your entitlements. Okay. The notice is a key to preserve your rights, and performance. Of course, you have to perform.
The next question is then what should be the deliverables from a contract analysis, either by the organization or the contractor himself or for the contract engineer? What should be the deliverable that he should be looking at?
When you use the word analysis, okay, earlier we talked about everybody reading the contract, correct? Now we are using the word analysis. When you read the contract, normally, what do? You are supposed to take some notes as you read the contract. Otherwise, this exercise of just reading the contract is becoming futile if you don't make your notes. Okay. So what notes do you try to make in an analysis, in a contract analysis? You try to look what are your obligations. Supposing the contract says you have to give me a time schedule within 10 days of signature of the contract. That is an obligation. A contract says you have to provide me a billing breakup for invoicing within 20 days. That is an obligation. You have to write down all your obligations. When the contract stipulates you should perform them. Simultaneously, you should write down all the obligations of the owner or your purchaser. He has to approve, he has to pay within a particular time, he has to give you land, okay? He has to depute people for training. So if you look at a contract, many project teams think that the client has no obligations. In fact, every client has got 20 to 30 obligations which he has to perform. So if they carefully read, list all your obligations, list the client's obligations. And when you read, you should also look if there are ambiguities in the contract. Okay. Suppose many of the contract documents are voluminous. Sometimes one section will say something, another section may say something else. You have to look which section has a priority over the other. Is there an order of priority defined in the contract for interpretation? If it is not there, then all these ambiguities you must note down. And noting down ambiguities itself is only half the exercise. You have to get these ambiguities clarified in time before an event occurs. Okay, if you want to get a clarification about something, you must get it well before that event occurs so that all ambiguities are resolved. Okay, and when there are ambiguities, you will not succeed in getting all the ambiguities resolved in the manner you like the contract to be interpreted. You may not succeed, but at least we should encourage the teams to settle all these ambiguities, because if you have ambiguities, it leads to claims. Okay. Then another important issue is what are the list of notifications to be issued, notices to be issued. See, supposing there is a delay in approving a drawing, the first person in the project team who knows that a drawing approval has been delayed is the project engineering manager. So we should try to delegate the task of issuing a notice of delayed approval. That delegation should be with the project engineering manager. I'm giving you an example, okay, because he comes to know about it first. So you must identify notices, try to delegate who will issue these notices, etc. And the other important thing which we do in Eka in a unique way is we try to plot a flow chart for closing out the project. How do we get back the performance bank guarantees? So we focus on all these aspects of closeout in our flow chart at the very beginning of the project, so that our teams are very well prepared at the beginning to handle a closeout. Because often when you get a contract, everybody thinks you take an excavator and go to site the next day. But the teams are being encouraged to stop, read, visualize what happens at the end, and plan for the ending right from the beginning. So this is something which should emerge from contract analysis. And Eka's method of flow chart is a very unique method, yeah, which will help you to bridge any gaps. If there is no duration for an approval, it will you in your when you plot the process, you will know that there is no duration for this approval. We should fix the duration. Okay. So this is the answer to this contract analysis deliverable.
Understand. From performance to deliverable, then we come into the question of how do we prepare such a claim? Once the analysis is complete and we are well focused on the performance, how do we then, move forward to prepare a claim?
Yeah, yeah. See, claims generally emanate from the contract amongst the contracting parties. Okay, if you and the purchaser or you and a subcontractor are in a contract, generally claims emerge from that contract. Okay, contract has some provisions, and generally remedies are also prescribed in the contract. Supposing there is a delay, you will be levied LDs. Otherwise, if it is not due to you, you will get time, and sometimes you will get money. So remedies are also prescribed in the contract. Okay. Most claims between the contracting parties emanate from the contract. Okay. Claims under the law generally come from third parties. Okay. Who are not parties to the contract. Okay. So we will set aside the claims which come from third parties who are outside the contract, because that is something which we insure for third party claims, and that is handled separately. So I will try to address this question about claims from within the contract. Okay. So amongst the contracting parties, claims could arise primarily due to non-performance of one of the parties or breach by one of the parties to its obligation. Okay. Normally, let's look at it in a very simple way. In every in a contract, there will be a clause which says if there is a delay due to the owner, then the contractor is entitled to extension of time and reasonable compensation. So first of all, there should be a contractual provision for such a relief. Okay. It will be there in most clauses, right? So what do we have to establish? A particular event happened. That means you were to do something on an X date and you did not do it on that X date. First, we should have evidence that there was an agreement that the owner had to do a particular task on a particular day. This is where we come into scheduling. When we do the analysis and we identify the owner obligations, some of these obligations which come from the analysis, owner's obligations, have to be put on the time schedule so that the owner knows when he has to perform these obligations. Okay. So he has not performed a particular obligation. We should have evidence. Okay. That you want to give me this land on such and such date. Here is the time schedule in which it was agreed. You have not given me the land. Here is the evidence. Okay. Now you have established that far that the owner has delayed in giving you the land. But the more critical part is how did that owner delay impact your completion date? Here we are talking about extension of time. Okay. Extension of time means the completion to the project has to be shifted. So this delay should be a critical delay. So the owner has failed to give you an input on time. And how did that impact your completion? Okay. So you have to establish that was a critical delay, or at that point of time when the delay took place, this event was on the critical path. So you should link the cause to the effect. This is the most important in claims. A delay event occurs, but that impacted my completion. Establishing that is the key. And for that, there should be scheduler, there should be records. Then you quantify what is the amount of extension you get or you want to quantify the claim. So it's simple. And then of course you should also establish that you should have given the purchaser the appropriate notice as is in the contract. So the claim cover letter could be very simple. Dear owner, you want to give me the land on such and such date. As per the time schedule, you did not give me up till this date. As per the contract clause number so and so, because of this delay, I am entitled to extension of time and additional cost. Here is my attached time schedule with the critical path showing the extension of time I'm entitled to. Give me extension of time and money. This is one way or the simplest way. But to establish all these with records, with these schedule updates, is the Herculean task. Okay, which means full project records should be always updated and readily available. Okay, this is the key to preparing a claim, any claim for that matter. Okay, then there is a second set of claims. Supposing there is a delay by the owner, but that was not under the critical path. Okay, so a non-critical activity has been delayed compared to what you had planned, and therefore there is no delay in the completion, but you would have probably had to spend longer resources or more resources over a longer duration. It has caused you a disruption, but not a delay. Disruption event claims are very difficult to make. You must have proper records to say, I have shown you this activity with 20 days float. Now I lost 5 days of it because of your delay. So I used so many resources additionally. Give me the money. So this is purely monetary. So these are largely the two types of claims we make. And then of course there could be some pure financial claims. You didn't pay me in time, give me the interest. This is a pure financial claim. So these are the three types of claims. And the more challenging ones are when you try to seek for an extension of time due to a delay. That is a more challenging claim.
I think that's very well articulated. And now we move on to the next question. After having prepared a claim, how do we now look at the issues that could come up for while negotiating a claim?
See, when you are negotiating a claim, okay, the client will first look to rejecting your claim. He will reject your claim, not the quantum of the claim, the basis of your claim itself. The client will try to reject. He will reject admissibility of your claim. Okay. He may come up with several arguments. The first argument he will come up with is you didn't give me a notice, so there is no entitlement. This is the first objection most clients come up with. Secondly, he may even say that this event did not occur. There was no delay because you didn't have a deadline by which he should have completed it in your agreed schedule. He may say there was no delay. The delay event did not occur. This is some defense he comes up with. Okay. The third thing is he will say, yes, there was a delay, but it did not impact you because you were also under delay. You were not ready. So my delay did not impact you. So he will bring all these arguments, okay, to say that admissibility of your claim is denied. Okay. And second set of questions he will come is there is no remedy for this delay in the contract. Okay. If there is a no remedy for that particular delay in the contract, he may say that. See, very classical example is in many contracts, interest on delayed payment, there is no specific mention. There is no specific remedy that if a owner delays a payment, you will claim you are entitled for interest. There is no such specific provision. So he may bring many of these arguments first to deny your entitlement. So if you overcome these admissibility issues, that's how whenever we evaluate a claim, the first thing we evaluate is the strengths of admissibility. Is this claim admissible under the contract? The quantum of the claim is secondary. The moment the client starts questioning the quantum of your claim, why 10 days extension? I'll give you 6 days. It is implied that you overcome the first hurdle. Then it's easier for you. Instead of saying 10, you can agree on 7, 8, 9, settle it. Okay. Or convince him that 10 is required. So while negotiating, first thing is admissibility, and then comes the quantum of the claim. Even for quantum of claim, you should have all the records. If you particularly have leading owners, engineers who have to evaluate the claim, they will if you say I spent 20 man hours, they will ask you to name the person who worked on site for those 20 man hours. They will even ask you for his attendance records to show that he was really on site on the days on which you have claimed. So the records to establish the quantum are also very voluminous, and many of them are checked very thoroughly by the lenders and owners engineers. Okay. So once you overcome all of these, then you can close with the negotiation. Of course, if you don't close, a claim in a negotiated manner, then you are in front of an arbitrator.
Okay, so essentially, records and record management plays an important role while you're negotiating.
Yeah.
And also perhaps the fact that, who blinks first is also an aspect that will have to be looked at when we start negotiation.
Yeah. See, and another important thing I like to add, Sajid, is these days we have digital photographs. Okay. unless unless contractor is prevented from taking photographs. Photographic evidence of circumstances and situations are very, very good supporting documents. Okay. Supposing you say it rained and there was flooding. If you have two pictures of an excavated foundation flooded, okay, with a digital number or digital date on it, this is an irrefutable record. Okay, so photographs of events are photographs are a very, very important record. They must be attached to progress reports or to claims. Okay. And
Also,
another important aspect is the need to write site diaries. Our engineers should maintain a daily site diary. What happened, what did not happen, they should write. I mean, they need not worry about whether a client signs these records or not. If our records are perfect, they can well be used in a claim.
very true. Very true. Site diary plays an important role. And I
Very
think
important.
at Eka Infra, we have actually been focusing on site diaries, and that's something that we have always used on our projects all the time. We come to the last question. I have actually deliberately skipped a couple of questions on delays and project insurance because we have covered many aspects and topics under this discussion. So the final question is basically, what is the difference between a contractual claim and a legal claim?
Yeah. See, as I mentioned earlier, between the contracting parties, claims generally come from the contract. Okay. Because when you negotiate a contract amongst the parties, okay, you try to build in certain exclusivity to say that the remedies are exclusive. Okay. Supposing you say liquidated damages for delay. If you say that if there are liquidated damages agreed, that is the exclusive remedy. So the either party cannot go under the law to claim additional damages over and above liquidated damages because you have agreed that it is an exclusive remedy and the law allows the contracting parties to make such agreements. Okay. Of course, legal if you say legal claims, I would say if there is an unsettled claim that goes to an arbitration, which really is a legal process because your lawyers are involved and only the arbitrators are the judges. So it's a legal process. Legal claims comes from third parties, okay, who are not parties to the contract. See, I will give you an example. Supposing uh, your truck driver is bringing concrete to your site and he damages a bridge belonging to the highways. Okay, the highways will claim you because your truck driver has damaged and he cannot claim you under the contract, he will claim you under the law. But this claim is coming under this particular project because for this project, a driver was driving through the bridge and your driver has damaged it. Okay. So this is generally a typical legal claim. Okay. So that I think is the difference. And generally, these legal claims. See, for example, if your truck driver damages a bridge, the highways department may even claim the purchaser, your owner, who's your project owner. They may claim him because they don't know the truck belongs to you. They may see that this belongs to this project. So in that case, if your owner receives a claim because of your breach, there is the indemnity clause. Each party indemnifies the other if he suffers a loss or damage or receives a claim, okay, which is not due to his fault. There is the indemnity clause. Okay. So that indemnity clause will kick in for these legal claims.
Okay, I think we have covered numerous terms under this discussion. Just out of curiosity, you used the word while, for warranties. Just
Yeah.
just wanted to understand, where did this terminology come from? Was it coined by someone within the contracting fraternity?
This was formulated by us, and when we used to distribute like a credit card, like you have a credit card. On the size of a credit card, we used to print the text of the of what should be checked in these four clauses. And we used to give it to our sales managers to say, when you go to negotiate, you don't have a lawyer, this is what you should check. If you have a doubt, go to the lawyer. So we had distributed what was called W.I.L.D cards. It is easy to remember. That's why I said W.I.L.D.
Okay.
Warranty,
Understood.
indemnity, liability, delay.
Excellent. Thank you. Thank you. I think we learned something new today. Um, I think this brings us to the end of this discussion. What I would now like to do is I would call upon one of almost all of our team members to ask
Yeah.
questions. We have exactly about 10 to 15 minutes to have this discussion, open discussion. If you can take turns in asking questions, raise your hand and then start with your discussions, please. Thank you. Here's Miller.
Yes, Srinivasan sir. Yes,
Yeah.
you discussed about the delay in non-critical activities.
Yeah.
So in the construction projects, the contractor submits the work program or the project schedule, and the critical path is defined in such a schedule. So can you tell who owns the free float and how do you substantiate that?
See, if the contractor has given a schedule to the owner, okay, showing him the float, right? It is the contractor's float. Contractor has planned resources for this project such that non-critical activities have these floats. Okay. So therefore, if you have given such a program showing the float to the owner, you have the right, contractor has the right to the float. The owner cannot use the contractor's float. If he does, he has to pay the contractor. You have to establish the quantum. Of course, you have to see how many resources you have planned, what happened, right? So that is the principle. There, there
Okay,
are
sir.
there are legal there are legal theories on this. Okay, who owns the float? Whoever uses it first owns the float. All these don't hold good if the contractor has given a proper schedule showing the float. Okay.
Okay, sir. Okay. Thank you. That answers. Yeah.
Thank you, Miller. One request is please identify yourself. I forgot to mention that. Yeah, Chintia, please go ahead.
Good morning, mine Achintya Mandal. Sir, during project execution, the critical path generally changes from time to time. Then what and how we should record those things?
Yeah. See, you are supposed to update the schedule every month at least in a project, correct?
Yes.
And during the process of updating, the critical path might change month to month, right?
Yes.
So every month when you submit the report, you will have a critical path, which may be different from what you had the previous month. Okay.
Exactly.
See, this is a very good question you raised, Achintya, because when you monitor a project, okay, time schedule, everybody in the project team, including top managements, monitor the critical path. Okay.
Yes.
So normally you should monitor loss of float. Understand? If you
Yes.
monitor which activities you are losing float, then you know potentially they will become critical. So in a project monitoring of time schedule, monitoring loss of float is a very key way to trying to forecast delays. Okay, possible delays. To say that these are potential delays because I'm losing float. So this is very, very important. And you're right, critical path will change. So if you monitor the float, then there is a good chance you can preserve the critical path as originally planned. Correct?
Yes, sir. Yes, sir.
Right.
Thank you. Thank you, Ajintya. Yes, Subhash.
Hi, Srinivasan, sir. Good
Hi.
morning, sir. Yeah.
Good morning.
So this is Subhash here, sir. Sir, I have a question like, what are the major challenges of a contract management, and how we can, as a contract manager, how we can overcome these major challenges, sir?
See, as I said, contract management is a team effort. Okay. Like you have a scheduler, you have an engineering manager, procurement person, finance person. Okay. You will also have a contract manager who has a defined role in the project. He is a member of the team, right? And all the other project team members should give him support because he leads in implementing the contract. Okay. Supposing you say that drawing list has to be submitted to the client on the 5th day after the contract. Okay. The contract manager will insist that that is done. An engineering manager may not be ready. He may feel why 5th day? I will give it on the 10th day. Okay. But as a team, you all should understand that once the contract is signed, each one has to fulfill his obligations, and that is what the contract manager is asking. Okay. And here the project director's support very much comes in. Okay. The project director, because see, contract management is a project management task. Okay. It is part of project management like scheduling or anything, right? Just because it's a new function in many companies, it gets misunderstood that he's an outsider. Don't tell him. This should not happen. He should be an integrated member, and he should also be proactive. The contract manager also has to be proactive. Okay. He has to show that he delivers results. Right. I don't know whether I answered your question.
Yes, sir. Yeah, yeah. That will meet my requirements, sir. Yeah. Thank you.
You. We have a couple of minutes more. If there are any questions, I think Srinivasan sir can take it. Yeah.
So Sajid, you said you just started the one question with insurance. Then you went off to the legal claims. Do you like to touch anything on insurance, or is it okay?
Sir, I actually deliberately skipped the delay in the insurance because we have already reached
Yeah.
about 45 minutes. Yeah.
Yeah. Okay. Right. Ask any other questions. Yeah. Any other question?
Yeah. Mallar is there.
Yes. So this is Malhar Anarse again.
Yeah.
Sir, now, in a contract, one party raises a claim to the other party, whereas the second party is silent, is non-responsive. Can the and unless and until the second party does not consent or otherwise disputes, it is the contract is not in dispute. So can the first party invoke arbitration according to the contract?
See, before invoking a dispute resolution clause in a contract, we'll lay down certain steps before you really go to an arbitration. Most contracts will say if there is something where there is a disagreement between the parties, the senior management should meet and try to resolve this matter. Okay. This provision will be existing, and even if this provision is not existing, it is very prudent that you should bring it to the attention of the senior management. Through appropriate senior management, you should say there is a claim you have not resolved. What is it you want to do? Okay. Only after that step also fails, and if there is a silence even in that step, which is very unlikely because they have to say yes or no when you have a senior management meeting. Okay. Then either party may invoke arbitration. If you feel the claim is strong, and if you feel that it is well worth, because arbitration is going to cost you. If the benefits of the claim outweigh the costs of the arbitration, then you should give a notice for arbitration after the management meeting.
Okay, sir. Thank you.
Okay.
Thanks, Mallar. I think pretty good insights. Yes, Desai sir, please.
Yeah, Srinivasan sir, good morning.
Good morning.
Ganapati Desai here.
Yeah.
How does the rules and regulation changes affect the contract?
See, rules and regulations affects the contract because most of the contracts will have a change in law provision. Okay. Supposing at the time you make the bid, there are a set of rules and regulations. This may apply even to a standard. Let us say an engineering standard is there, okay, for design at the time of your bidding. And when you are going into execution, supposing that rule or regulation changes and becomes more stringent, okay, then you are supposed to pursue a change order under the contract for a change in law. You should notify the owner that this law has changed. This is impacting my price. This is impacting my time. This is impacting my guarantees. Therefore, give me a change order. And change in law provision there generally is there in every contract. Okay.
Okay, sir. Thank you.
Okay. Welcome. Welcome. It could be even tax laws. For example, if there's a change in taxation, tax rates change, and you have included taxes. So you can always go back to say that this is a change in law. Okay. So of course, the very good question you brought up is we should read the change in law clause in a contract to see that it is complete and covers all such changes. Okay.
No, noted, sir. Thank you.
Thank you, sir. Yes, Priyanka.
Hello, Srinivasan sir. This is Priyanka Raul. So my question is how the finance manager can assist in like contract management and contract management.
Yeah. See, for the finance function is a very very vital function to support contract management, because at the end of the day in contract management, okay, what are we looking for? We are looking for collecting our due money which we have overspent if it is not due to our fault. Correct. Quantifying all these costs is it cannot be done by a contract manager. It has to be done by a finance manager. And I mentioned also finance manager monitors the budget. Okay. Whenever there is an overspend or there is a potential for overspend, he has to proactively bring it up with the contract manager to see why this is going to happen, who is responsible, and from where can we get back this money. So it's a very proactive function for a finance manager. Okay. Second thing is in finance manager, supposing we decide that we are going to make a claim. Okay. For example, let us an insurance damage and we have to make a claim. The finance manager for such a claim, he normally opens a separate account number and he asks all the members of the project team if they spend any money towards this item of claim or this item of insurance damage, they should book their expenses under that particular new head of account which he has opened for that particular claim. Okay, so he very well supports the preparation of claims, identification of potential claims. All of this he definitely supports the contract manager. It's an interactive, proactive function.
Okay.
Yeah, is it okay, or you have some more doubts?
No, sir. It is okay. Yeah. Thank you, sir.
So thank you. I think that has been an excellent discussion with quite a lot of questions coming in. As we come to the end of this discussion and this session, sir, any final say on the entire discussion that we have had so far?
No, the understanding of the team, whoever were party to this, is very good. Okay, they have a very good understanding of contracts. Okay, but one underlying message which everyone should bear in mind is, if you don't perform, the contract manager cannot support you. He is not a magician. So performance of your obligations is the key. Just because you have a contract manager, don't expect that if you don't perform, you will be saved. This is the message we have to give to everybody.
Very true. Very true.
Yeah, yeah. Otherwise, the team has understood the contract management. Yeah.
Okay. Thank you. Thank you, sir. And thank you, everybody. As we conclude this, one message to the audience and the people who are going to hear this out is, I would invite you to engage with us once you have gone through this or heard it out, so that the outcome is far more beneficial to a larger audience than what we are focused on. With this, we conclude our session. Thank you. Thank you so much.